Today, we're going to be discussing trust administration and the role of trustees and or executors. Some of the first questions we like to ask: do you know what happens to a loved one's estate when he or she passes? Do they have a trust? Do they have a will? There is a big difference. Who's in charge of the estate? Who's in charge of the trust? Sometimes they're different. Who are the heirs? Are they the heirs or are they just named beneficiaries? Are they family friends? Are they extended heirs? What's the market value of their assets? Have you gotten them appraised? Will you get them appraised? Will you sell them? What are the decedent's final wishes? And do we have to go to probate? All of these questions get asked when a loved one passes away and they leave behind some assets, right? There's two types of trust administrations. There's a trust administration at the second death and then trust administration at the first death, which we call it a partial administration because you're basically setting it up to protect the surviving spouse and also protect the future beneficiaries as well. And if you don't do it, I am certain everyone has heard, oh, I was the child of my mom, my dad. They were in a second marriage. And then when they passed, everything went to the surviving spouse and his or her kids took everything. We got nothing. So there's ways to prevent that. And you want to do that preventively prior to becoming incapacitated or passing. So the process of the first death, right? You take a look, was your trust divided into two buckets? Maybe it's the survivor's bucket and the bypass bucket or the decedent's bucket. There's various different names that can occur for this bypass, the marital, and then there's the survivors as well, depending on the complexities of the trust and also depending on how much assets were left. So at the death of one, basically in a very simplistic manner, you want to separate it and put it into two buckets. One is irrevocable, one is revocable. The one that is irrevocable is being preserved for the benefit of the future beneficiaries, but it also supports the surviving spouse as long as they are alive. And so there's a process to do this where you want to collect all the assets, divide them up, make sure you can take advantage of any estate tax issue. And then, of course, the protection for the surviving spouse is key as well. You have to really allocate which assets go into which bucket so that you get a double step up in basis or a step up in basis at the second death. So the first steps, you want to locate the documents. What do the documents say? You want to look and see, were they funded properly? Were the bank accounts inside the trust or the savings accounts, or was it life insurance named as the trust as the beneficiary? What about homes? What about rental properties? What's going on and where do the assets sit? And we have a situation right now where not all the assets were fully funded into the trust and the decedent died. And now spouse is having to collect those assets that were her sole and separate property of the decedent. They were not named properly with beneficiaries. And so, yes, we have to open up probate. Or can we do a 850 petition, which is something that we're saying, look, the decedent forgot to put this property into their trust and we're going to court. But again, you're going to the probate court for this issue to see if they will approve it. And not all trusts are the same. And so some trusts don't even allow you to ask for court permission to move the assets into the trust. So when somebody passes, you definitely want to collect all the documents. You want to collect all the assets. And then we always say, please notify us so that we can help you through the process. Because as a trustee or an executor, you owe a fiduciary duty to all the beneficiaries, right? The future beneficiaries. And so there's certain notices that have to be given out. So we give these notices out to make sure that the trustee will not have any liability later on down the road. So when you're reviewing the documents, you want to make sure and understand what you have to do. And do you have to open up probate or can you bypass the probate process? When somebody passes, you do have to lodge the will within 45 days of the passing of the decedent. So you want to make sure and get that done as well. So when you're reviewing it, there should be a schedule of assets and you want to see who the beneficiary is. If it's just a partial administration, usually the beneficiary is the surviving spouse. But many times if there's a blended family, there's assets that will be distributed to the decedent's as well. And so sometimes there's specific distributions. If there are credit cards in the deceased name, you want to make sure and close those credit cards out because of fraud. You definitely want to get an appraisal of joint property and separate property so that you get that step up in basis. So beneficiaries often reach out. The trustee, the executor, they won't send me a copy of the trust or the will. What kind of rights do I have? And the trustee does owe a duty to the beneficiaries, and they should send out notices regarding the administration of the trust. And if you are an heir of a decedent, if you're a child, then you are entitled to notice. Even if you were disinherited, you are entitled to notice so that you can potentially contest the way it was done. Was there any undue influence? Was there shenanigans being performed when the decedent drafted their trust or signed their trust or made amendments, right? Many times the decedent makes amendments close to death, and perhaps there's some undue influence there. So you want to be very specific. You want to make sure that the beneficiaries are notified, and they have 120 days, basically, if notice is properly done, to contest any of the terms of the trust. And once that time period passes, then they cannot bring a cause of action, which relieves the trustee of any fiduciary liability. Many times at the death of the first, there are no distributions being made because it's all for the support of the surviving spouse. But what is the role of the trustee? The role of the trustee is a very high standard, and they have a fiduciary standard or a duty of loyalty and impartiality. They have to maintain confidentiality with the various different beneficiaries as well. And usually what happens is we would represent the trustee. And so all communications can go through us so that the trustee does not have to answer phone calls or give descriptions of what's going on. And the trustee really, even if they are a beneficiary, they wear two hats. They wear the hat of the trustee and they're the manager, but then they are also the beneficiary. So they have to do a little bit of role changing. And while they're serving as a trustee, they are acting in the best interest of all the beneficiaries, not just in the best interest of themselves, right? And same thing with us representing them. We are representing them in the capacity as a trustee, not as a beneficiary. And if there are issues with the beneficiaries, they have to seek their own legal counsel. So a trustee has the duty to collect all the assets, to get appraisals for the assets, to send notices to financial institutions, to do an accounting to the beneficiary. There's special trust accounting that has to be done. And if they are serving as a co-trustee, they can't just willy-nilly act on their own behalf. They have to act with their co-trustee and make sure things are being done correctly. They have to file a final tax return. They have to follow the terms of the trust. And if they don't seek legal counsel, they can be liable and responsible for not clearly carrying out the wishes of the decedent, the grantors, and i.e. the terms of the trust. They owe a duty to do that. But the trust can pay for them to seek legal counsel. They don't have to do it all themselves. So when does a trustee get in trouble? Can a trustee be removed? What kind of issues can arise? So if a trustee is distributing assets to one beneficiary but not another beneficiary, there is a liability. They have to pay for all of the expenses. They have to pay for if there were any estate tax. It all comes from the trust. Nothing comes from their personal account. Everything is part of the trust, the assets that the decedent left behind. And they must follow the protocol and follow what the terms of the trust state. So trustees can misbehave. And I always say if a trustee misbehaves, they can be removed, right? A beneficiary can't say, oh, my parents said I can have a car and I want a Maserati. Well, no, the terms of the trust say a fair and reasonable car. It doesn't say an exotic car. So if a beneficiary wanted to remove the trustee because they didn't give them money for an exotic car, the trustee is not going to be removed, right? The trustee is only removed if, in fact, let's say that the beneficiary is in college and it says they're supposed to pay for college tuition and they're not paying it because they're embezzling it or they're commingling it with their own assets. Those are the type of issues that a trustee can be removed. And this all has to be done through the probate court. And usually it's a beneficiary that wants to remove a trustee. Sometimes it's successor trustees that they believe that they will do a better job than their older brother or sister, and they try and get them removed. But it's a lot of responsibility. And the trust is created to protect the trustees who are serving, but it's also created for the beneficiary's best interest as well. So while it's going through the administrative process, the trustee, they have carte blanche to follow the terms of the trust. Now, if they misbehave, absolutely they can be removed. But until it actually gets distributed or sub-trusts are created for the beneficiaries, the trustee has lots of power to make their decisions, right? Because if they didn't have the power, nobody would serve as a trustee. So it's a fine line, but they have to follow the terms of the trust. And the terms of the trust are very much connected with the probate code as far as what they can and cannot do. And so a beneficiary many times will seek representation to make sure that the trustee is following the terms and there's no hocus pocus going on. So if there's no trust, guess what? If somebody passes with just a will alone, a will does not avoid probate. Many times there could be assets that are in the decedent's name alone, and you have to open up probate. Sometimes employment benefits have to be paid to the estate. And if that's the case, then you have to open up probate. So the process begins. You could be conducting your trust administration at the first death or second death, and at the same time, you still have to open up a probate, and they can work simultaneously. But if you open up a probate, usually if you're doing a trust administration, there's a will or it's a pour over will. And the pour over will gets admitted to probate. But once the assets go through probate, it pours over and it gets distributed according to your trust. So these are for assets that are over 184.5, right? And so if that's a house, if that's a benefit, if it's life insurance, etc., the trust can pay to open up this probate. And then once you go through the probate process, then it's going to pour over and be distributed according to the trust. And so what is this probate process? You have to lodge the will with the county in which somebody passes. Then you have to file a petition to open up probate. Then somebody gets appointed as the executor or the administrator. It's the executor in a will, the administrator if there is no will, and then they have to collect all the assets. All of the assets have to get appraised, and there's what's called an inventory and appraisal that gets done by a probate referee. And there are fees, of course, involved with this. You have to give notice to beneficiaries. And again, there's the probate code that has to be followed when you're going through the probate process. And that's where we step in and we assist and we do all of the legal work during the probate process. However, the executors do have to go to the banks, right? And they give what's called letters to say, oh, we now have control to put this asset that was in the decedent's estate into an estate account. So the whole process usually takes a year to 2 years. It's starting to get a little bit better during COVID. There was taking like 3 years to get through the probate process. You really want to try and avoid probate like the plague is what I always say. So you're in charge of all of the assets. And then at the end of the day, when you close out the probate, it's because those assets are going to pour over and be distributed according to the trust. So if there were sub-trust of the main trust, they get distributed into the main trust. But nothing can really be distributed until everything's ready to close, because you could be doing an accounting, there could be a lawsuit where a beneficiary is claiming more interest or the trustee is misbehaving. So you can't piecemeal anything. Everything has to be done jointly and simultaneously. So, how is this probate calculated? Here's an example of various different types of assets. And even if you have a pour over will, which means that everything's going to be distributed according to the trust, any of these assets are going to cause probate fees and costs, right? And it's 5% of the fair market value. So, as you can see here, 2.730 probate estate, nice little nest egg if you were leaving it for a couple of kids to get through college, etc., down payment of a house, just starting out. But look at that, $135,000 in probate fees alone. So you want to try and avoid that. I think 135,000 could be used a lot more efficiently and even invested and meant to grow a lot faster than having to pay probate fees. So we always say, yes, can you do it yourself? Of course you can, but you need to understand the laws, you understand your responsibilities, deadlines, and making sure that the process is complete. Because if you leave it lingering, you're going to hold that liability that a beneficiary can come and sue you at any given point in time. So who wants to do that? So you want to make sure you're properly represented. And then when you close out the trust administration or when you close out the probate, you want to make sure releases are signed, right? You want to have those beneficiaries say, yes, I have been able to see the accounting. It's been transparent. I am good. This is my distribution. I'm signing off and I'm relieving you of all liability. And then, whew, you are relieved and you can go on with your life because being a trustee is a lot of responsibility. And sometimes you might want to have a professional step in as well. So here at the Soto Law Group, we do the planning and then we do the administration. And then we clean up the messes for those that fail to plan. And so we have a full team of experienced team members here. I am the owner of the Soto Law Group, and I oversee everything that comes through our office at this point in time. But we do have two other attorneys, we have two other paralegals, we have a legal assistant, and then, as many of you know, we have Anita Morin, who is the organizer of everything and our communication director. And so, if you'd like to set up an appointment, you can go through Anita, and there is some paperwork that has to be done, right? And if we are reviewing trust and doing the administration, then we need to see what these documents look like, see who's in charge, see what kind of assets are involved, and see if everything was fully funded. And Anita can assist you with that and make sure everything runs smoothly. Here's our contact information, having us review your trust and want to give some guidance before you get started. We can do that. There is a small fee because it is very time consuming to read through trust documents and wills and to give some advice as well. But we're here to assist. And hopefully, if you're listening, you have done all the planning yourself and you have all your ducks in order, and your administration will be smooth whenever you pass on. Someone had a question about professional trustees. Absolutely. We have a list of professional trustees if you wanted one to be appointed. And I'm going to say, usually when there is a dispute with trustees, a court will say, okay, we are appointing a professional to step in. We had just a trust admin that was going on, oh goodness, for a couple years. And we had siblings fighting and disputing each other. And we just recently had a professional to step in. So, yes, I think professionals can be very beneficial when family members don't get along or siblings, there's a tug of war, or if there's a lot of assets. Sometimes having a professional step in is the best way to go. In regarding POAs, yes, we can do powers of attorney for finances, power of attorney for healthcare documents, and of course, I am not a proponent of doing anything yourself because that is where things go south. Sometimes you don't fill out these illegalzoom.com documents. And so then guess what? Those are the documents that end up in the probate court. And those are the documents that people end up disputing, whether it's because of undue influence or capacity issues. You really want to make sure that things are done properly, that your wishes are being carried out. I used to argue with people, why do you want to do it yourself? And I came to the conclusion that, you know what, I'm not going to argue with someone. If they want to do it themselves, go for it. Because I always say, I will catch you on the back end when we have to go through probate or a conservatorship would be necessary. So I hope to see you all soon. And again, if you have any questions that come up, please feel free to reach out to us and we can get you on our calendar and do a trust review. And like I said, there's a small fee for reviewing documents, of course, because it is time consuming. So thank you very much and hope to see you soon.